You should never add your children to your deed. This is perhaps the most common estate planning mistake I see people make, at least in the top 2 throughout the state of Florida. And I get the instinct, right? The goal is, I have my children, I want them to own this property after I pass away. This is my most valuable asset. I want to make sure that it doesn't go through the Florida probate process. So that makes the goal, and the reason why people do it is completely understandable. But there's a much better way to go about doing it. Because here's the thing, if you add your children to the deed now, before you pass away, when you do pass away and they receive that home, they are going to get a significant tax hit, generally speaking. The reason is because you lose the ability to obtain what's called a step up in basis. If your children inherit the home after you pass away, meaning they're not present owners but are only become owners after your death, they get this step up in basis. Here's an example of the potential significant application of that, right? So here I am located in South Florida, although we help people throughout the state. There are plenty of people who bought homes in certain parts of Miami in the 60s and 70s for $70,000, $80,000, $90,000. And if they've kept the house all this time, a lot of those homes are now worth $500,000 or more. Okay, so a significant appreciation of value of this asset. Well, if they put their children on the deed before they pass away, and then they pass away, and then the children go to sell the house, they will pay taxes on the difference between the original purchase price, right? That's $60,000, $70,000, $80,000, and the value of whatever it's worth now, right? The fair market value in their sale. So you can see that could be a huge tax hit. As opposed to if they inherit the house, whether it's through probate, or we're going to talk about how you can still avoid probate, right? You can still accomplish the same goal, but if you do it through another way, you can get the step up, and your kids can get the step up in basis where they will only pay taxes on the difference on the value of the home at your death. That's the step up. Versus what they sell it for, right? So that could be no taxes or very, very little taxes, as opposed to paying taxes on the value of the property when they sell it and the original purchase price from decades earlier, right? So you can save a ton of money in taxes by making sure your kids inherit the house but don't own it before you pass. There are 2 ways of doing this in a way that will still allow your children to avoid going through probate to obtain title to the home. The first is what's commonly referred to as a ladybird deed. This is also sometimes referred to as an enhanced life estate deed. And the idea is we literally change the deed, that on the deed it would say, you, the original homeowner, still own this house. You're the only owner of the house. You can do whatever you want with the house. But if you own the home or condo after you pass away, on the deed it will say who then gets it. Right? And because it's in the deed itself, you don't have to go through probate. It kind of automatically, or through the death certificate has to be recorded, but very, very quickly, the title ownership interest can pass to who's ever listed on that deed in what's called the remaindermen section. They're called remaindermen, the people who inherit the home only after you pass away. And that's one way of doing it. The potential problem with that is that if one of them pass away, right? If your children, one of your children predecease you, you may be back in the world of probate to figure out what happens with their share. So another way to avoid the probate, to get that step up in basis, to get that tax benefit, is by putting the home inside a revocable trust or a living trust. These are 2 terms that mean the exact same thing. Very similarly, the home will be owned by the trust. It's still yours to do with whatever you want while you're alive. It's still your homestead. You don't lose that benefit, right? So there's no really real drawback to it, but the revocable trust will say who gets the home after you pass away. Now, what's a little bit nicer about the revocable trust, as compared to the ladybird deed is you can say what happens, meaning you can determine if the home is going to be sold within a year of your passing and then the proceeds split evenly. You can determine, say, maybe I have this one child who is more likely to want to live there, so we'll give them the ability to get a fair market value appraisal and buy out the other child share for 50% of the fair market value, right? So we're more malleable in terms of what happens. This also prevents fighting, right? Because on a ladybird deed, or even if you add multiple children to your deed, they have to agree to do anything with that property. They have to both sign. They have to both agree on anything. I'm assuming 2 kids, right? Obviously more, it gets more complicated. But with a trust, you can say what happens or dictate, how the home is going to pass, how it's going to be sold, who's going to have the opportunity to buy it and under what terms. And so again, you prevent fighting because the instructions are right there in the revocable trust. So again, don't add your children to the deed. Use either a ladybird deed to pass property to your children or put the home into a trust, which will say who will get the home or how the home will be disposed after your passing. Hope this makes sense. If you have any questions, you're anywhere in the state of Florida and want to talk about estate planning, Medicaid planning, probate, or probate avoidance, please give us a call, schedule a consultation. Thank you for watching.